I'm delighted to be here this afternoon. As suggested, my talk derives from a book I just completed, which will be released next spring, titled Sex and the Constitution, which examines the history of sex, religion, law, and the Constitution from the ancient world to the 21st century. And although the book addresses such issues as obscenity, contraception, homosexuality, and abortion, I will focus this afternoon on the issue of same-sex marriage, an issue that cuts to the very heart of the meaning of equal citizenship. So in August of 1982, an Atlanta police officer went to the home of one Michael Hardwick to serve an arrest warrant for public drinking. Upon entering the home, the officer observed Hardwick and another man engaged in oral sex. The officer placed both men under arrest for the crime of sodomy. In Bowers versus Hardwick, decided in 1986, the Supreme Court of the United States held that Georgia's prohibition of homosexual sodomy was not unconstitutional, noting that the Constitution says nothing about a right to commit sodomy and that prescriptions against homosexuality have ancient roots. Justice Byron White, who wrote the majority opinion, concluded that to claim that the Constitution protects a right to engage in such conduct is at best facetious. In a concurring opinion, Chief Justice Warren Burger added that condemnation of homosexual conduct is firmly rooted in Judeo-Christian moral and ethical standards, and that to hold that the act of homosexual sodomy was somehow protected by the Constitution would be to cast aside millennia of moral teaching. Justice Harry Blackmun, joined by Justices Brennan, Marshall, and Stevens, dissented in the case. Although conceding that traditional Judeo-Christian values had prescribed homosexual intimacy for hundreds, if not thousands of years, Blackmun insisted that that fact alone could not provide an adequate justification for the Georgia law. That certain religious groups condemn the behavior at issue, he reasoned, gives the state no license to impose their judgments on the entire citizenry. To the contrary, he explained, the legitimacy of secular legislation depends on whether the state can advance some justification for its law beyond the conformity with religious doctrine. Finding no such justification, Blackmun concluded that the Georgia statute could not be reconciled with the United States Constitution. But that was a dissenting opinion. Now, the court's invocation of moral and religious prescriptions against homosexuality played a central role in the justice's reasoning in Bowers, and it's therefore useful to have some understanding of that history. So let's take a look at the ancient roots that Justice White invoked. The pre-Christian world generally thought of sex as a positive part of human nature. It did not see sex as bound up with questions of sin or religion. The ancient Greeks, for example, focused not on sexual sin, but on whether an individual's conduct was harmful to others. This extended even to homosexuality. Indeed, a common feature of classical Greek sexual life was that adult men often had same-sex sexual relationships with adolescent boys. Now, this might seem strange to us, but Greek poetry, history, and literature celebrated such relationships and identified them with love, honesty, integrity, honor, and courage. Similarly, although Roman sexual life was different in many respects from the Greeks, the Romans too celebrated sexual pleasure, and neither Roman religion nor Roman law condemned same-sex sex. The emergence of Christianity, however, produced a profound change in the prevailing understandings of sex. By the end of the 5th century, Christianity had come to condemn sexual desire as inherently shameful and as an evil temptation that must be suppressed. This shift occurred over the course of several centuries, but it was Augustine who finally crystallized the early Christian understanding of sex. In a critical leap, Augustine linked sexual desire to the fall of man. Adam's transgression, he argued, had not been one of disobedience, as the ancient Hebrews had believed, but one of sex. Augustine therefore maintained that every sexual desire is born out of evil, that every child born out of evil is born into sin, and that it's through sex that man passes on the original sin from one generation to the next. Augustine therefore concluded that man's only hope for redemption lay in repudiating the sexual impulse, and with it the burden of sin and shame inherited from Adam. Augustine's vision ultimately shaped the future, not only of Christianity, but of Western culture and law more generally. During the next 1,000 years, Christian dogma, backed by the threat of hellfire and damnation, attained not only religious, but social, political, and legal authority. The sin of sodomy came to be seen as uniquely dire, for as the biblical story of Sodom had taught, for this particular sin, God will punish not only the sinners, but also those who fail to prevent the sin. It was still unclear, though, precisely what acts constituted sodomy. It was Thomas Aquinas who, in the 13th century, first drew a sharp distinction between opposite sex and same-sex unnatural acts. Although oral and anal sex with the person of the opposite sex was deemed a vice against nature, such acts with the person of the same sex, he concluded, constituted the worst form of sodomy. Before long, Thomas's thinking on this point became the dominant authority in Christian doctrine. At roughly the same time, and not coincidentally, same-sex sex came to be declared not only a sin, but also a crime. That is, the church, for the first time, conscripted the secular law to extend its prohibition on same-sex sex not only to those who shared the faith, but to everyone, regardless of their personal religious beliefs. Criminal statutes against same-sex sex were thus enacted throughout Europe, and because of the heinous nature of this crime, these laws called for homosexuals to be castrated, dismembered, burned at the stake, drowned, hanged, stoned to death, decapitated, or buried alive. In short, homosexuals, for the first time, became the object of a systematic program of extermination. Now, although the Reformation brought about significant changes in the Protestant attitude towards sex generally, those changes did not extend to homosexuality. To the contrary, Protestant reformers reaffirmed in no uncertain terms the traditional condemnation of homosexuality as a detestable and abominable sin. In the American colonies, for example, the Puritans declared that sodomy must be punished with death without mercy, and warned that the land cannot be cleansed until it hath spewed out this unclean beast. By the time of the American Revolution, the colonies, under the influence of the Enlightenment, had stopped using the criminal law to prosecute most forms of consensual sex, except for the crime of sodomy, which remained a capital offense. And indeed, sodomy remained a serious felony in every state in the nation for the next 200 years. Throughout all of this history, until the late 19th century, it was generally assumed that individuals who chose to engage in same-sex sex were no different than other individuals who chose to engage in other types of criminal or sinful behavior. Engaging in homosexual sex, like engaging in oral sex, anal sex, robbery, murder, was simply a choice. The assumption along these lines began to be questioned, however, in the late 19th century, as medical authorities became interested in the issue. For the first time, persons drawn to same-sex sex began to be seen as individuals possessed of a distinctive psychological identity. It was in this era that the concept of the homosexual first came into being. Leading studies of homosexuality in the late 19th century posited that homosexuality was a pathology, and that persons afflicted with this pathology were strange freaks of nature. Among the questions debated were whether the inclination to engage in homosexual conduct was congenital or acquired, whether it was curable or incurable, whether it should be accepted as an unavoidable condition or actively resisted and suppressed. Physicians in this era proposed a broad range of remedies for homosexuality, including hypnosis, psychoanalysis, sex with prostitutes, intense bicycle riding, rectal massage, burning the neck and lower back with chemicals and hot irons, electric stimulation, castration, and clitorectomy. Many doctors recommended the sterilization of homosexuals in order to prevent the condition from being passed on to the next generation. And by 1938, 32 states had enacted compulsory sterilization laws aimed at homosexuals. Also in the 1930s, the image of the homosexual took on an increasingly sinister cast. A growing public anxiety over sex crimes recast the dominant image of homosexuals as dangerous psychopaths who were naturally inclined to commit the most unspeakable crimes. Demonized not only as perverts, but now as child molesters as well, homosexuals became the new enemy of the people, and arrests for sodomy increased dramatically in the 1930s. During World War II, the United States, for the first time, attempted to prevent homosexual men and women from entering the military. And those who were discovered in the military were discharged in proceedings that often left them branded for life. With the advent of the Cold War, things got even worse. Fearful of domestic subversion, Americans turned with a vengeance against homosexuals. The conflation of communists and queers seemed only logical, for Americans viewed communism as atheistic, unchristian, immoral, and degenerate. As one congressman asserted in 1950, the Russians are strong believers in homosexuality. And red-baiting journalists warned that communists are now converting American youth to homosexuality in order to defeat us from within. By 1950, the Lavender Scare, as it came to be called, was well underway. Government agencies began using lie detectors to determine whether their employees were homosexuals. The FBI compiled lists of suspected homosexuals from local vice squads. And President Eisenhower issued an executive order officially declaring sexual perversion a serious security risk. In light of the intensity of the anti-homosexual fever that gripped the nation during the Lavender Scare, gays and lesbians found themselves increasingly isolated. In a society in which the dominant religion excoriated homosexuality as a heinous sin, the law branded it a vicious crime, and the medical profession diagnosed homosexuals as diseased, the vast majority of homosexuals did their best to hide their secret shame from family, friends, neighbors, employers, and associates. The terrible fear of discovery kept the secret lives of most homosexuals invisible even to one another. Indeed, even civil rights groups turned their backs on gays and lesbians in this era. In 1957, for example, the National Board of the American Civil Liberties Union declared, quote, that it is not within the province of the ACLU to question the validity of laws aimed at the suppression or elimination of homosexuals. By the late 1960s, though, inspired by the civil rights and women's rights movements, a handful of courageous gay men and lesbians began calling openly for the acceptance of homosexuals as equals in society. In 1969, for example, Carl Whitman, a gay SDS leader, penned what he termed the Gay Manifesto. In this document, he declared, quote, "Our first job is to clear our own heads of the garbage that's been poured into them. Liberation for gay people is defining for ourselves who we are. It is time for us to come out." This was the first time that anyone had used the term "come out" in this manner. For those who sought equal rights for gays and lesbians, coming out was a radical and daring act that would affect every aspect of their lives. Indeed, as late as 1969, only a few hundred members of the growing gay rights organizations in the United States had publicly dared to identify themselves as homosexuals. The next decade saw gradual but halting progress in the cause of gay rights. In 1972, a lesbian was allowed to retain custody of her children in a contested divorce for the first time in American history. In 1973, the American Psychiatric Association declared for the first time that homosexuality was not a mental illness. And by the end of the decade, 22 states adopting the recommendation of the American Law Institute had repealed their laws, making consensual sodomy a crime. But these developments sparked a sharp backlash. The most dramatic explosion arose over a proposed gay rights ordinance in Dade County, Florida. In 1977, the county commission passed an ordinance prohibiting employment discrimination on the basis of sexual orientation. Local religious groups were outraged and demanded an immediate repeal of the ordinance. Local Baptists charged that the law violated God's biblical commandments, and the National Association of Evangelicals soon entered the fray. Leaders of the Christian right, including Jerry Falwell, Pat Robertson, and Jim and Tammy Baker, came to Miami to campaign in favor of repeal. And in the special referendum, Dade County's voters repealed the ordinance by an overwhelming margin. This victory generated momentum for a new religion-based anti-gay movement. The campaign took on an ugly tone as bumper stickers appeared across the nation with such messages as "Kill a queer for Christ." Within 2 years, many of the laws that had been tentatively enacted in cities across the nation to protect gays from discrimination had also been repealed. Soon thereafter, AIDS struck the gay community with a vengeance. As the disease became associated in the public mind with homosexuality, the Christian right deemed AIDS God's punishment for homosexual sodomy. The Reagan administration, which had actively courted the Christian right, had no interest in devoting government time or money to an illness that was thought to threaten only gay men. Rather than invest federal funds in medical research, the White House instructed the Center for Disease Control, quote, to look pretty and do as little as you can. Over the course of the next decade, AIDS ravaged the homosexual community, killing more than 250,000 gay men and leaving hundreds of thousands more to wonder if they might be next. Ironically, though, the horror of AIDS brought homosexuality into the light. As thousands of gay men died horrible deaths, people had to take notice, often, though not always, with sympathy and concern. Gradually, one person at a time, in often awkward and sometimes excruciatingly painful conversations with family, friends, and acquaintances, the previously closeted lives of homosexuals became visible, first out of necessity, despair, and desperation, and then later out of candor and self-respect. Gay invisibility was suddenly melting away. At the Gay and Lesbian March on Washington in 1993, thousands of individuals wearing pink triangles marched proudly past the White House. 4 years later, Ellen DeGeneres, star of the popular ABC television show Ellen, came out as a lesbian. And shortly thereafter, some 42 million viewers tuned in to watch DeGeneres' character, Ellen Morgan, reveal that she too was a lesbian. Not everyone cheered. The response of the Christian right was fierce. The Reverend Jerry Falwell called Ellen DeGeneres Ellen Degenerate. And Donald Wildman, the president of the American Family Association, railed that homosexuality was a sin grievous to God and repulsive to Christians. This struggle, he declared, is a matter of life and death, because if we fail, we fear the judgment of God on our nation. The battle lines had clearly been drawn. This brings me back to the Supreme Court of the United States. As we saw earlier, in its first encounter with homosexuality, the court held in Bowers versus Hardwick that a state could constitutionally make homosexual conduct a criminal offense. The court explained that given the history of religious and moral condemnation of homosexuality, any suggestion that the Constitution could be interpreted as protecting such behavior was, at best, facetious. The court's second foray into this arena was a case called Romer versus Evans, which was decided in 1996, exactly a decade after Bowers. Now, as I noted earlier, beginning in the late 1970s, cities around the nation enacted ordinances prohibiting discrimination on the basis of sexual orientation. As in Dade County, however, this generated a sharp response from the Christian right, which almost always succeeded in getting those laws repealed. In Colorado, after Aspen enacted an anti-discrimination ordinance in 1991, a coalition of Christian right organizations launched an aggressive campaign to amend the Colorado Constitution to override the ordinance. Amendment 2, which was adopted in a statewide referendum, provided that neither the state of Colorado nor any of its subdivisions could enact any law or adopt any policy that protected homosexuals against discrimination. 9 days later, lawyers from Lambda Legal and the American Civil Liberties Union, which by now had changed its tune, filed suit, claiming that Amendment 2 violated the Constitution of the United States. Now, in light of Bowers, it seemed clear that the Supreme Court would reject this challenge. But in a stunning 6-3 decision, the court held Amendment 2 unconstitutional. Justice Anthony Kennedy, who had been appointed to the court by President Ronald Reagan, authored the court's opinion. In Kennedy's view, the problem with Amendment 2 was that it imposed a special disability only upon homosexuals. This was so because under Amendment 2, every group in Colorado was free to try to persuade a city council, a state university, or the state legislature to enact regulations protecting them against discrimination, except homosexuals. Because of Amendment 2, only homosexuals would have to amend the state constitution before they could obtain protection against discrimination. With that fact in mind, Kennedy turned to the Equal Protection Clause of the 14th Amendment, which provides, quote, that no state shall deny to any person the equal protection of the laws. Now, under that guarantee, if a law treats some people differently from others, as almost every law does, it ordinarily will satisfy the demands of equal protection if it bears even a rational relationship to some legitimate end. And although almost every law passes that highly deferential standard, Justice Kennedy concluded that Amendment 2 did not. This was so, Kennedy reasoned, because a law declaring that it shall be more difficult for one group of citizens than for all others to seek aid from the government was virtually unprecedented in American history. And it was therefore impossible to escape the inference, he explained, that the disadvantage imposed on homosexuals by Amendment 2 was the result not of any rational effort to further a legitimate government interest, but of animosity toward the class of persons affected. Because a bare desire to harm a politically unpopular group cannot in itself constitute a legitimate government interest, Kennedy concluded that Amendment 2 violated the Equal Protection Clause of the United States Constitution. Justice Antonin Scalia, joined by Chief Justice Rehnquist and Justice Clarence Thomas, was of a rather different view. Scalia maintained that Amendment 2 is not a manifestation of a bare desire to harm homosexuals, but is rather a rational and perfectly legitimate attempt by Coloradans to preserve traditional sexual mores. He castigated Justice Kennedy's reasoning as utterly disingenuous. The Supreme Court's third decision involving the rights of homosexuals, Lawrence versus Texas, was pretty much a rerun of Bowers versus Hardwick. Police officers in Houston were dispatched to a private residence in response to a reported disturbance. After they entered the residence, they saw two men engaging in anal sex. The men were arrested, charged, and convicted of violating a Texas statute, making it a crime for any person to engage in deviant sexual intercourse with another individual of the same sex. Now, since 1982, Bowers v. Hardwick had been used by politicians, legislators, and judges to justify discrimination against gays and lesbians in deportation hearings, adoption proceedings, military discharges, employment discrimination, and a host of other contexts. After all, if homosexual conduct can be criminal, then a homosexual is no different than a rapist, a robber, or a thief. But much had changed in the 17 years between Bowers and Lawrence. Not only had AIDS devastated the gay community and changed the public's perception of homosexuality, but 60% of Americans now thought that homosexual sex should no longer be deemed a criminal offense. And in the 6-3 decision, the Supreme Court overruled Bowers v. Hardwick and held the Texas statute unconstitutional. Justice Anthony Kennedy again delivered the opinion of the court. Although conceding that the framers of the Constitution had not themselves expressly guaranteed the right to engage in homosexual sex, Kennedy explained that the framers had intentionally left some constitutional guarantees open-ended because they knew that later generations could see that laws once thought proper, in fact, served only to oppress. That, Kennedy maintained, was the situation in Lawrence. There was, he concluded, no constitutionally legitimate justification for making same-sex sex a crime. Justice Antonin Scalia, joined once again by Rehnquist and Thomas, dissented. Scalia accused the court of signing on to what he termed the homosexual agenda, and he fumed that the court had no business invalidating legislation that had been legitimately enacted by the citizens of Texas. Echoing Justice Scalia's outrage, religious conservatives throughout the nation were livid. Pat Robertson denounced the court for rending the moral fabric of the nation. Jerry Falwell warned that Lawrence would lead to bestiality, and a pastor in Kansas fumed that it marked the death knell of American civilization. When it came time for Justice Kennedy to announce the judgment of the court in Lawrence, he read a brief statement explaining the result from the bench. The Supreme Court chamber was packed. At the end, Kennedy declared, quote, "Bowers was not correct when it was decided, and it is not correct today. It ought not to remain binding precedent. Bowers versus Hardwick should be, and now is, overruled." It was a remarkable moment. Overwhelmed by what was happening, many of the gay and lesbian advocates sitting in the gallery sobbed openly. For the gay and lesbian community, it was an occasion for dancing in the streets. Joyous demonstrations erupted in cities across the nation. For gays in America, Lawrence meant much more than that rarely enforced anti-sodomy laws could no longer be legally enforced. Rather, Lawrence meant that never again would their rights be dismissed by the highest tribunal in the land as at best facetious. And never again would they wonder whether the words engraved on the pediment of the Supreme Court building, "equal justice under law," included them. The Constitution was now their Constitution, too. In San Francisco, a group of veterans who'd been expelled from military service during World War II because of their sexual orientation proudly saluted as a huge rainbow flag, which had flown atop an 80-foot pole for more than 5 years, was lowered, and an American flag for the first time was raised in its place. For most of American history, the notion that a man could marry a man or a woman could marry a woman seemed utterly absurd. In 1990, however, only 4 years after Bowers versus Hardwick, 3 gay couples in Hawaii applied for marriage licenses, which were, of course, denied. Audaciously, they then filed suit in the state court of Hawaii, claiming that the state's refusal to allow same-sex couples to marry violated Hawaii's constitution guarantee of equal rights on the basis of gender. To pretty much everyone's surprise, the Hawaii Supreme Court ruled in 1993 that the state's law restricting marriage to a man and a woman might violate the Hawaii Constitution. This decision provoked a furious response from the Christian right, and almost immediately states across the nation rushed to amend their state constitutions explicitly to define marriage as involving only one man and one woman. The goal of these amendments was both to prevent their own state courts from following at some point in the future the Hawaii Supreme Court's suggestion, and also to make it impossible for future majorities in the state, should they ever emerge, to legalize same-sex marriage merely by enacting legislation to that effect. They would now have to amend their state constitutions to do so. These issues played out at the national level as well. As the 1996 election approached, the anti-gay rhetoric was virulent. Dick Armey, the Republican whip in the House, publicly referred to Congressman Barney Frank as Barney Fag. And Republican Speaker of the House Newt Gingrich proposed the Defense of Marriage Act, or DOMA, which provided, among other things, that if any state recognized marriages between persons of the same sex, persons entering into such marriages would be ineligible for the multitude of federal benefits that were otherwise available to all married couples. The hearings on DOMA were openly homophobic. Members of Congress described gays and lesbians as, quote, sick, perverted, and dangerous, charged that the nation was facing a dangerous attack upon God's principles, and warned that the flames of hedonism are licking at the foundations of our society. Congress quickly enacted the legislation, and with the presidential election just around the corner, and with the American people opposed to same-sex marriage by a margin of 68 to 27%, President Bill Clinton signed DOMA into law. Now, of course, none of this really mattered at the moment because same-sex marriage was not legal in any state in the nation. 7 years later, though, in 2003, the Massachusetts Supreme Court held that laws denying same-sex couples the freedom to marry violated the Massachusetts Constitution. Massachusetts thus became the first state in the nation to legalize same-sex marriage. In response, 13 additional states promptly amended their state constitutions also to forbid same-sex marriage. Several years later, though, the state Supreme Courts of Connecticut, California, and Iowa followed Massachusetts' lead, and they also held that their state constitutions guaranteed same-sex couples the right to marry. But the pushback, again, was furious. In California, the Christian right launched a vigorous and successful campaign to enact Proposition 8, which amended the state constitution to outlaw same-sex marriage. And voters in Iowa, spurred on by the moral majority, voted out of office the state Supreme Court justices who had voted to recognize a constitutional right to same-sex marriage. As executive director of the American Family Association warned, if any judge attempts to impose an immoral agenda on this nation, we are going to take you out. Thus, despite several seemingly landmark victories, the movement for same-sex marriage had stalled. DOMA remained the law nationally. Most efforts to legalize same-sex marriage had been overruled. And by 2013, more than 30 states had enacted state constitutional amendments expressly outlawing same-sex marriage. This brings me to the Supreme Court's fourth decision in our story, United States versus Windsor. In a bitterly divided 5-4 decision, the Supreme Court invalidated DOMA on June 26, 2013, 10 years to the day after its decision in Lawrence v. Texas. As in Romer and Lawrence, Justice Anthony Kennedy again authored the opinion of the court. Chief Justice Roberts and Justices Scalia, Thomas, and Alito dissented. In his opinion for the court, Justice Kennedy explained that the issue presented was not whether states were constitutionally obligated to recognize same-sex marriage. Rather, the issue was whether the federal government could constitutionally discriminate against couples who were legally married in a state because those individuals happened to be of the same sex. In approaching this question, Kennedy emphasized that a state's decision to give same-sex couples the right to marry conferred upon them a dignity and a status of immense import. DOMA's principal effect, Kennedy maintained, is to identify a subset of state-sanctioned marriages and to make them unequal. He argued that by placing legally married same-sex couples in the position of being in a second-tier marriage, DOMA demeans such individuals, demeans such marriages, and humiliates tens of thousands of children now being raised by same-sex couples. Because no legitimate federal interest justified a law disparaging those whom the state sought to protect, Kennedy concluded that DOMA violated the United States Constitution. In a furious dissenting opinion, Justice Antonin Scalia characterized the court's reasoning as nothing short of remarkable. At various points, Scalia dismissed Kennedy's analysis as, quote, perplexing, confusing, absurd, overcooked, and, famously, legalistic argle-bargle. Scalia reiterated what he had insisted upon in Lawrence. The Constitution, he said, does not forbid the government to enforce traditional moral and sexual norms. Scalia angrily predicted that Windsor would lead to recognition of a constitutional right to same-sex marriage. As far as this court is concerned, he fumed, no one should be fooled. It is just a matter of waiting for the other shoe. Now, it's striking how far the court had moved in the 27 years from Bowers to Windsor. This was due to several factors, one of which was not an overall move of the court in a more liberal direction. To the contrary, on a broad range of issues, including affirmative action, campaign finance, gun control, and voting rights, the court, with the additions of Justices Scalia, Thomas, Kennedy, Roberts, and Alito, had grown, if anything, notably more conservative than the court at the time of Bowers. What had changed in those years was the public awareness of gays and lesbians in society and the public and legal understanding of both the morality and the wisdom of laws that discriminated on the basis of sexual orientation. Indeed, public opinion on these issues had shifted dramatically between Bowers and Windsor. In 1986, no one even bothered to poll on the question of same-sex marriage. It wasn't until 1996 that Gallup finally thought even to ask people the question. At that time, in 1996, only 27% of Americans thought same-sex marriage should be legal. By 2013, however, 54% of Americans now shared that view. Now, this shift was due to many factors, but most important was the profound change in the visibility of gays and lesbians in American society. This transformation, due in large part to AIDS, affected not only everyday citizens, but also legislators, mayors, governors, presidents, judges, and justices of the Supreme Court. With these changes, the traditional judicial understandings of such fundamental legal concepts as liberty, equality, and due process, as applied to homosexuals, were suddenly called into question, and rightly so. But it's important to note, though, that these changes in public attitudes and understandings did not in themselves dictate any particular change in constitutional doctrine. Bowers and Windsor were both 5-4 decisions. Only one vote had changed over the course of those 27 years. Had Robert Bork been confirmed to the Supreme Court, and Anthony Kennedy therefore never been appointed, the outcome in Windsor almost surely would have been 5-4 the other way. So my point, though, is that the divergent outcomes in these cases were shaped by at least two critical factors: the general public understanding of homosexuality at the time of the decision, and the particular interpretative approaches and values of the individual justices who happened to be on the court at the specific moment when the issues arose. Now, in the years after Windsor, there was a virtual avalanche of lower court decisions invalidating state laws, denying same-sex couples the freedom to marry. The other shoe, as Scalia had promised or feared, was indeed about to fall. Now, Obergefell v. Hodges decided just 1 year ago, 2 days to the day after Windsor, the Supreme Court, in another bitterly divided 5-4 decision, held that states cannot constitutionally deny two persons of the same sex the freedom to marry. The opinion, written once again by Justice Anthony Kennedy, was premised on what Justice Kennedy described as the transcendent importance of marriage. Although conceding that marriage had traditionally been understood as between a man and a woman, Kennedy declared that it is both appropriate and inevitable in a free society that new dimensions of freedom become apparent to new generations of American over time. Kennedy concluded that although the limitation of marriage to opposite-sex couples may have long seemed natural and just, its inconsistency with the central meaning of the fundamental right to marry, he said, is now manifest. Predictably, Chief Justice Roberts and Justices Scalia, Thomas, and Alito dissented. Roberts accused the justices in the majority of rampant and reckless judicial activism. The majority's decision, he declared, is an act of will, not of legal judgment. The right it announces has no basis in the Constitution. Justices Scalia, Thomas, and Alito authored similarly scathing dissenting opinions. Scalia, for example, charged that the majority's opinion lacked even a thin veneer of law, and that it is a naked judicial claim to super-legislative power fundamentally at odds with our system of government. And Justice Alito railed that the decision evidenced a deep corruption of constitutional interpretation. So who is right? The mere fact that 5 is more than 4 does not in itself make the 5 right. So who is right? So let me offer a few observations. First, the fury expressed by the dissenting justices in their condemnation of the majority's opinion in Obergefell is completely unwarranted. Although there are reasonable grounds to disagree with the court's decision, there is nothing about the decision itself that merits the screeching charges of judicial usurpation of the democratic process hurled by the 4 dissenters. Indeed, those very same justices have embraced highly controversial and highly activist interpretations of the Constitution. For example, in awarding the 2000 presidential election to George W. Bush, in holding affirmative action programs unconstitutional, in holding gun control regulations unconstitutional, in holding laws regulating campaign expenditures and contributions unconstitutional, and in holding the Voting Rights Act unconstitutional, to cite just a few examples. For them to purport to stand tall on the pedestal of judicial restraint is nothing short of hypocrisy. Second, there are, in fact, reasonable grounds on which to disagree with the court's analysis. In invalidating laws prohibiting same-sex marriage, Justice Kennedy relied on the argument that marriage is a fundamental right, and that government, therefore, cannot constitutionally limit the right to marry without a compelling justification. But the very notion that the Constitution protects unenumerated fundamental rights has always been controversial. Although the Constitution expressly protects the freedom of speech, the freedom of religion, the freedom from unreasonable searches and seizures, and other expressly delineated rights, a central puzzle in constitutional interpretation is whether the Constitution also implicitly protects other rights that are not expressly spelled out in the text. Now, historically, the Supreme Court has recognized that such rights do exist, including, for example, the right not to be sterilized, the right to use contraceptives, the right to privacy, the right to vote, the right to decide whether to bear or beget a child, the right to raise one's own children, the right to travel, and the right to marry. But the recognition of such unenumerated rights is always a tricky business, because it gives the justices potentially broad authority to override the democratic process by imposing their own value judgments about what rights they think are fundamental. Thus, as the dissenters in Obergefell argued, one constraint that has sometimes been suggested is that the court should recognize such implied fundamental rights only if the acclaimed right is one that is deeply rooted in our nation's history and tradition, and that the law that's challenged is a fundamental departure from that tradition. Marriage, of course, is such a right. But as the dissenters argued, how we think about that right in this context depends on how we define marriage. What is deeply rooted in our nation's history and tradition, they argue, is marriage between two people of the opposite sex, not marriage between two people of the same sex. Thus, in their view, the court in Obergefell was not protecting a right that was deeply rooted in our nation's history and tradition, but was instead creating an entirely new right out of whole cloth, a position that they insist is beyond the legitimate authority of the Supreme Court. Now, although this is in fact a reasonable argument, it is not compelled by the actual process of the Supreme Court over time. In defining implied fundamental rights, the court has not, in fact, limited itself to such a narrow conception of what is traditionally have been recognized as a right. But the point is certainly an arguable one, and the dissenters' objection is not in itself in any way crazy or irresponsible. Third, my own view is that the court in Obergefell should have decided the case not on the ground that marriage is a fundamental right, but on the ground that discrimination against gays and lesbians violates the Equal Protection Clause, whether it involves marriage or anything else. The Supreme Court has long held that laws that discriminate against individuals on the basis of so-called suspect classification are especially problematic under the Equal Protection Clause, and they are therefore unconstitutional, even if they're rational, unless they can survive a demanding standard of justification. Because laws discriminating against African Americans are the paradigm violation of the Equal Protection Clause, the court generally considers several factors in determining whether discrimination against any particular group should be deemed suspect. For example, it considers whether the group has experienced a history of invidious discrimination, whether the defining characteristic of the group is essentially an immutable one, and whether the group can effectively protect itself against discrimination through the political process. Now, those who challenge the constitutionality of laws that discriminate against gays and lesbians maintain that such discrimination satisfies these criteria, and that such laws are therefore presumptively unconstitutional. In response, those who defend the constitutionality of laws that discriminate against gays and lesbians argue that homosexuality is a choice, it's not immutable, that what homosexuals call a history of discrimination is therefore no different than a history of discrimination against arsonists, robbers, and murderers, and that gays and lesbians have ample political power. Thus, in their view, laws that discriminate against homosexuals are completely different constitutionally from laws that discriminate against African Americans or against women or against Hispanics or against Japanese Americans, all of which have been held to be presumptively unconstitutional. Now, in my view, this equal protection rationale would have been a better basis for the court's decision in Obergefell. Gays and lesbians have been subjected, unquestionably, to a long history of invidious discrimination. Sexual orientation is not a matter of choice, and gays and lesbians have consistently had their interests dismissed and overridden in the political process. Put simply, and especially in light of the history I described earlier, laws that discriminate against gays and lesbians, whether in marriage, child custody disputes, employment, housing, or any other context, should properly be understood as constitutionally suspect in the sense that they are likely to be tainted by considerations of animus, hostility, ignorance, and prejudice. This, to me, is the deepest and truest reason for invalidating laws that discriminate against gays and lesbians. Moreover, unlike the marriage is a fundamental right basis for the court's decision, the suspect classification argument would render all government discrimination against gays and lesbians unconstitutional, as it should be. I'd like to close with one final observation. For most of American history, a particular understanding of religion has dictated the law on issues like sexual expression, contraception, abortion, and homosexuality. In the past half century, though, due largely, though not entirely, to the Supreme Court, those religious values have largely been pushed aside, and individuals have increasingly been freed to act on their own personal and religious beliefs, rather than be dictated to by the religious beliefs of others. This is a great achievement in a society dedicated to the separation of church and state. But it now leaves us with an interesting challenge. For our Constitution also guarantees the freedom to practice one's religion. And with the demise of the religious state, those who hold to traditional Christian values now find themselves, for the first time, on the defensive. No longer able to dictate that others must act in according to their religious beliefs, they now demand that they at least be permitted to act in accord with their own faith. Hobby Lobby demands the right not to provide contraception to its women employees. Kim Davis demands the right not to sanction same-sex marriages. Catholic priests demand the right not to marry same-sex couples. And florists, bakers, hotel owners, and restaurant owners demand the right not to participate in same-sex marriages. Now, these are not easy questions for one who values both the separation of church and state and the freedom of religion, as I do. Perhaps the most astonishing thing about the Supreme Court's decision in Obergefell, though, is that the backlash to the decision has been so tepid. Now, that may change over time, but I think not. We can and should bask in the glory that our nation has taken another important step in our protection of human dignity and equality. We have many steps left to take but this is one we should genuinely celebrate together. To gain similar celebrations in the future, however, we constantly have to be willing to challenge the accepted wisdom. We must always remember that we, like those who went before us, hold beliefs that our children and our children's children will rightly come to believe are naive, foolish, and bigoted, even though they do not seem so to us today. As we strive to fulfill the obligations of citizenship in a free society, we must have the courage, the open-mindedness, and the integrity to question the conventional wisdom and to challenge the nature of things. Thank you.